Why is there a hesitation to deal with public access to information? Now, first off, we had the abandoning of the referenda with misleading statements in this honorable House and the robbery of the democratic rights of the voters of this country. Then we have the infamous Jetgate, where you had the Premier and two other ministers.
Point of order, Mr. Chairman. That member may well be aware, because he has a written hand, that if he states into certain areas is sub judice, there are facts that have been aired out in other places. He can show up with his lawyers there and deal with them, but he can't do it here.
Mr. Chair,
the facts are sub judice.
Point of order, thank you. The leader will give. Point of order. Actually, it's a point of information. No doubt the chair will agree, as per Mays, that the matter concerning sub judice, once it's in the public domain, it no longer is sub judice. This is a matter of public record. Hansard will report the comments that have been said since May and repeated constantly since that time.
Mr. Chair,
Chairman, that's totally incorrect. That is totally incorrect. And the rules are very clear with regard to that, right? Once it's in the domain of the court, then the matter is not to be discussed in this place, whether it's been discussed ad length or ad nauseum somewhere else. Just like if you say it here and then you go on TV and say it's something else, you put yourself in a different position. And they're now in a different position, especially that honorable member's in a different position.
I hope, Mr. Speaker, that the public are listening, because we're debating public access to information. Okay? I hope that everyone is listening to our learned AG, who's trying to use some Mickey Mouse excuse of sub judice.
Point of order. Point of order. That's irrelevant. Point of order. That member is using inappropriate language in this place. The rules of sub judice are ancient, and he should not be using that type of language. Those are the rules. They're clearly stated, and he cannot get into it. He needs to come to court and deal with what he has to deal with, and then he can talk about it for long.
I don't even think we'll get there. Mr. Chair. Mr. Chair.
Yes, honorable member.
Jetgate is a matter before this House since May. Okay? A ministerial code of conduct was ignored. In fact, the learned AG,
point of order, Mr. Chairman, that's not agreed to at all. That honourable learned member needs to check carefully with the rules. The Speaker's had a look at this. These matters sub judice because of things that he has said in a different place, and they are in court and cannot be discussed here. They've been discussed ad nauseum. He shouldn't be bringing them up now.
Mr. Chair, I understand your predicament, right? But Jetgate and the writs were based on allegations made inside and outside this House of a particular instant, a particular matter. It has nothing to do with Jetgate unless someone up in here is suffering from a guilty conscience. Now, I will return back to public access to information. Now, we had Jetgate. Okay, we had Jetgate. I'm not intimidated by the legally you speak. I know what ground I'm standing on. We had the Premier and two honorable members go to Washington, D.C.
Chairman, you're going to have to rule on this because he's trying to take advantage of the situation. Check with the Speaker. The matters he's skating into are sub judice. Those are issues, if he reads his writ, that are before the court in a different place. We've aired them out ad nauseum. There's nothing new to bring. He just needs to be cornered in what he can talk about. If he wants to talk about public access, then do that, but not in relation to matters that are before the court.
Mr. Chairman, point of order. No, it's okay. Can you take your seat, please? I have a point of order. The learned and honorable Attorney General is misleading this House according to the 23rd edition, 2004 of May, Erskine May Parliamentary Practice. I'd invite you to have a look at this. Matter sub judice, and I'm reading from page 525. The sub judice rule is not absolute. The leader of the House, or in this case the chair, exercises the general power of waiver and also a power of waiver in specific circumstances which are described below. The House has agreed that the practice governing motions and questions related to the matter should be similar to the Houses of Parliament, since it is desirable that each House should be put in the same position. The rules governing sub judice do not also apply to bills, measures, or delegated legislation or proceedings on them. Should I continue? Do you want me to continue?
Is it clear?
Would you like for me to continue? Continue reading?
Thank you. Thank you, Madam.
Thank you.
Thank you, Madam Leonard Shadow AG. Again, the irony is that we're speaking about public access to information. And now, I guess the public can understand why we had this apparent attempt to silence the discourse of holding the government to account. After months of breaking the ministerial conduct, the code of conduct that the same Leonard AG got up and said he wasn't around at the time that he broke them rules. He wasn't even aware of it. Then a few months later, 9 months later, we find out there was a third or fourth party on the aircraft, and then we find out two contrasting accounts of where, what, and when by the minister and the premier. No wonder Petty has seen the cut in his budget.
Order. Speaker, clarification, misleading the House. There's no conflicting stories here. None whatsoever.
There's not a point to order, and I know you don't have a hands up, Mr. Chair, but I can get a copy from Hot 1075. Right, while the premier was holding the closest thing to a Banana Republic press conference where he banned journalists from entering there, didn't take no questions. When the minister of tourism said something else on live radio.
Point of order. Take your seat. In reference to Rule 11, Mr. Chair, you're going to have to look at it with regard to that honourable member's conduct and what he's saying. Just to be very clear, these are our rules of the House with regard to debate. Reference shall not be made to any matter which is sub judice in a way which might, in opinion of the Chair, prejudice the interest of parties here too. D. It shall be out of order to use offensive and insulting Banana Republic or disrespectful language about members of the House or which tends to bring the House of Assembly into disrepute. F. No member shall impute improper motives to any member of the House or indulge in personalities except on a substantive motion moved for that purpose which is not here. Mr. Chairman, I'd ask you to have those rules in front of you. When that honourable member starts to speak, you'll find that he will state over any one of those at any time, and a point of order will be called. And I'll repeat them again.
Point of order, Mr. Chairman. Yes. Continuing on from Erskine May, the rules governing sub judice are subject to the proviso, Mr. Chairman, again at page 525, where a ministerial decision is in question or a case concerns issues of national importance, such as the economy, public order, or the essential services, and I would respectfully submit, such as misleading the public insofar as this whole Jetgate episode, and not recognizing what the powers are insofar as the ministerial code. That I respect. Oh, they're going to get the speaker? He can't come back. That I respect, Mr. Chairman, with the greatest respect, is a matter of public importance. We are debating the economy and public order or the essential services. Those rules governing sub judice. Do you want to take your legal advice now? Those rules governing sub judice, according to Mays, are exempt. So therefore, I would respectfully submit that we are talking about the economy and the budget, and it is a matter of public importance, national importance, as it relates to the issues that were raised in May. Previously, Hansard has reported it concerning the issues of Jetgate.
Point of order, Mr. Chairman.
Honourable member.
Mr. Chairman, I hope we can start to bring some sensibility to this debate. The comments that were read by the honourable member, the honourable and learned Shadow Attorney General, are totally inappropriate for the purposes of that to which we are now speaking. Mr. Chairman, the matter, the honourable member indicated that the matter was of national importance. It was relating to all of those issues, according to Erskine May, are not in accordance with what our House rules indicate, which the Attorney General has indicated. Let me just say that we aren't trying to shy away from debating the issue. It is just the question of the appropriateness of the manner in which that issue continues to be brought to this honourable House. And I would like for you, Mr. Chairman, to make a ruling on this so that we can continue with this debate in an appropriate manner. Thank you, sir.
The honourable members, the
we can, honorable members, if we can focus and get back to focusing on the budget and on the stuff, that the individual stuff that's happening.
Thank you, Mr. Chair.
Thank you.
Mr. Chair, again, the irony of all this hoopla is that if there was actual transparency and accountability, we wouldn't be having this discussion. But in the absence of accountability and transparency, we get this circus. A circus. That there you have the minister, the honorable member, Ms. Gordon Pendleton got up with the right face, say, hey, come on, let's get along, and this is really getting out of hand. What's making it get out of hand is the learned AG refusing to have the light of accountability and transparency shined upon him and his colleagues' actions.
Point of order. Members impugning improper motives in relation to
I'm not accepting it.
With regard to the fact that I'm trying to close down some transparency, I welcome transparency. It's just a fact that it's a matter of subjudicy. He is the one who respects. That honourable member is the one that caused that to go there, as all the members on his side know, right?
Mr. Chair, I will continue. But I know myself and two of my colleagues and my business manager didn't jump on the plane to Washington, D.C. for free. On taxpayers' dime, in the sense that they still got paid, they still got a salary. So it is a matter of public record. And this happened 9 months ago. Okay? Yeah, because for seeking accountability and transparency, I don't know if the One Bermuda Alliance think they could hide from this issue, but you could, well, because up until this point, they've been running and hiding. Okay? Every time we ask questions on it, the story changes. 9 months later, we find additional information. It's recorded for all to hear and see. So let me move on. Because again, we're talking about a key component of delivering the objective of good governance, transparency, and accountability, right? It's being honest focus. So we had the abandonment of the referendum, the robbery, the piracy of democracy in December. We had the ill-fated Jackgate, and it's ill-fated, trust me. We had the refusal to disclose the compensation packages of the Tourism Authority employees, taxpayer-funded funds. To this day, we still don't know who the CEO and COO got compensation packages using taxpayer money. And then when we ask for transparency, when we ask for accountability, we get, again, another